Welcome to today's webinar on the China Initiative and your research grant. We now turn the session over to Gang Chen. Take it away.
Thank you, Shra. Welcome each and every one of you to our event. It is our great honor to have Catherine Pan as our speaker tonight. Before turning to our moderator, Adam Lee, who will tell you more about our speaker, Catherine, I would like to spend a few minutes with you for the introduction of who we are and what we do. Chinese American Biopharmaceutical Society, CABS for short, is one of the largest life science professional organizations in the Bay Area, where we headquartered. CABS was founded 21 years ago. It was a nonprofit and volunteer-based organization. I'm one of the volunteers. My name is Gang Chen, co-chair of International Collaboration Committee. We have over 3,000 of members and 17,000 subscribers globally. Our event focuses on science and other topics like this today. Wait a second. Our mission is to serve all the professionals in the life science and also to promote the public awareness for the progress and development in the life science industry and collaboration with other organizations. We have year-round event focused on science and other hot topics. For example, as you can see from the slides there, in the past 1 year, CABS have organized 12 free webinars from 14 speakers and moderators to our communities and over 12,000 of attendees globally. So we know life is hard during this pandemic. And in addition to the webinar, our members do what we can do to help the society. As you can see from this slide there, CABS have donated over 30,000 of value of the PPE to 18 hospitals in the United States. Thank you for all the donors here. And all this work is under the leadership of our current president, Dr. Tian Yang, and President-elect, Dr. Kelly Wong, and the effort, of course, and all of our volunteer members. But we cannot have all this done without the support from our previous and current sponsors. We have different level of sponsorship. If you want to do this, see my next and the last slides. Yeah, our flagship event is the Avenue Bio-Pacific Conference. The theme of this year is the passion for better medicine, especially true during this pandemic this year. And please save the date, October 30. Bio-Pacific Conference usually attracts hundreds of attendees, as you can see last time, that is 2019, you can see over like 750 attendees. So if you want to be our sponsors and exhibitors, please contact us. Thank you. And now I want to hand it over to our moderator, Adam. Adam, please.
Thank you very much, Chang. My name is Adam Lee, and I'm a practicing attorney with JunHe Law Offices, and I am focused on U.S.-China transactions. So with 700 lawyers across China and 2 in the U.S., we are very much good at doing healthcare related work. Like in China, we represent Bayer, Stryker, Danaher, Eli Lilly, Pfizer, etc. We also help many healthcare companies doing financing, doing listing, licensing, IPOs in Shanghai and Hong Kong. For example, just in this month, we helped listed New Horizon Health Limited, the first cancer screening company listed in Hong Kong. In the past 2 years alone, we helped listing 21 public companies on healthcare in Shanghai, in Hong Kong, and on NASDAQ. So CABS and my roles crossed in early 2020 when Chang mentioned that we were teaming together to donate PPEs to the US when this country is in desperate need of masks and other equipment. We together donated more than 1 million PPEs and masks to this country. And early this month, thanks to Alex Chang, the past president, I was introduced to the current leadership of CABS because I did so want to introduce a very good lawyer, a friend of mine, a leading corporate lawyer, active in the East Coast. But now I want to introduce her to the West Coast, where CABS is headquartered. As we all know, the incident of the well-respected MIT scientist Chen Gang has drawn a recent discussion and close attention from the Chinese scientist community in America. And this is not a lone case. And many people are wondering what could Chinese American scientists could have done better to avoid such charges in prosecution and defend themselves in a court of law. Catherine Pan is a partner of a leading US law firm, Dorsey Whitney, with a very established China-US practice group. And he sits on the management committee, and that firm, Dorsey Whitney, has a China initiative, our response team, and to defend the scientists. So it's Catherine's call to defend, to help the Chinese American scientists and to navigate them through difficult territories, situations to keep their jobs, research grant, and the freedom. So I am very privileged to have attended the same law school as Catherine and many, many years ago. So the way we are going to handle this is Catherine is going to give us a 1-hour presentation about the federal grant and the related questions. And then we'll open the chat room for like 20 to 30 minutes question and answers. I will pick up the questions to present to Catherine for her to answer. And please note, you should feel free not to reveal your identity. Actually, you should not reveal identity if you think it's sensitive. Now it's my honor to introduce my dear colleague, Catherine Pan-Giordano, for the presentation. Thank you.
Thank you very much, Adam. Good evening and good afternoon, everybody. Thank you, Gang Chen from CABS, and thank you, Adam Lee from JunHe, for inviting me. I am really humbled and flattered by this invitation. Adam is actually somebody I have respected and admired since my law school days. So it's actually my privilege to work with you, both of you, tonight. So the purpose of this webinar is to provide information and help scientists and researchers like all of you understand how to stay out of trouble in light of the current environment. I will not discuss my opinion regarding the underlying regulation, policy, and enforcement actions because I oftentimes represent clients and negotiate deals with prosecutors. So I want to remain in a relatively neutral position to be as helpful as our clients as possible. So I will not discuss whether the China Initiative enforcement policy and the direction that the country is going is the right direction. While I understand and I'm very sympathetic to the sentiment about the political racial profiling and discrimination, I think today the most helpful thing for me to do is to really educate the audience and help you understand how not to violate the law and how to protect your rights, your family, your career, and your freedom. Now, as Adam said, you should feel free to ask your questions during any of my part of my presentation. Your name, if you register with your real name or a pen name that you use to register, will only be visible to me and to Adam. Nobody else can see it. So rest assured. And when Adam, as the moderator, summarize the questions, he's not going to mention who asked this question. So you should feel free to ask this question. In fact, a few of my friends asked me if it's okay to attend this seminar because they're a little bit afraid. This tells you, just the general atmosphere of universities and research institutions these days. I can tell you there's nothing wrong about getting yourself educated about compliance and legal regulations. In fact, the government wants everybody to be educated and trained in this area. I'm sure your university's research integrity office is doing the same training work that I am doing. So there's nothing wrong about attending this webinar or asking any questions. Do not worry about it. But in any event, the registration list, your names and your questions will remain confidential and anonymous. Now, we can advance. Sean, if you can help me advance to the first slide. Thank you. So as you know, on November 1st, 2018, the Department of Justice launched its so-called China Initiative. This is a criminal enforcement and investigation initiative. So this initiative is designed to confront China's national security threats and to protect US technology. Under this China Initiative, the DOJ, Department of Justice, has been prioritizing US government enforcement actions against the Chinese companies and persons doing business in the US or persons partnering with Chinese universities and entities. The DOJ has been focusing also on individual researchers, professors, and scientists with ties to China. On the next slides, you can see that under the China Initiative, the DOJ, FBI, and other federal authorities have investigated and prosecuted many Chinese persons for trade secret theft cases. They also targeted individuals, universities, and companies for transferring technology to China. Under the China Initiative, they engaged US universities in identifying and monitoring persons and companies with so-called tie to China. A lot of foreign talent program participants have been targeted, including the well-known 1,000 Talents Scholarship Program and the Changjiang Scholarship Program sponsored by the Chinese government and universities. So under the China Initiative, the US government has been aggressively using the existing laws and authorities to really scrutinize people seeking to obtain US companies' IP. So when scientists and researchers came to me and asked me, Catherine, what are the legal basis for them to do all these things to us, right? Arresting scientists, prosecuting them, put them in jail, terminate their contracts and tenure with the universities. What rights does the government have to do this? Well, there are a long list of the existing laws that the government has been relying on to prosecute these cases. These are the names that you may not be familiar with, but they actually apply to your day-to-day work as a university researcher or a researcher or scientist as a hospital or a lab worker. You may not have heard about these laws, but they actually apply to your activities. I'll give you a quick rundown and then we'll go through some of the detailed aspects later. False Claims Act. This is a federal law that applies to your grant applications. So for example, if you submit a research grant application as a PI or a co-PI to NIH, NSF, or any other federal grant-making agency. And if you have misrepresentations or material omissions in those grant applications, the Federal False Claims Act applies. The basic essence of this law is to say, if you're applying for grants, which are basically US taxpayers' money, and if you lie about your background or other information such as, pending and current support, if you have mistakes and omissions in your bio sketch, it's really a fraud. You're trying to defraud the US government and taxpayers out of the funding. So the False Claims Act applies to research grant applications. Foreign Corrupt Practice Act, that is probably the law that's less relevant to most of the audience today, the Fcpa. However, it basically applies to a US company or person doing business in a foreign country like China. And if somebody commits a bribery in the business activity with a Chinese government official, the Fcpa applies. And for most researchers, if you deal with Chinese university officials or hospital officials and doctors, you probably know most Chinese universities and hospitals are owned by the Chinese government and controlled by the local governments. So hospital officials and university officials are considered foreign officials under the Fcpa, the Foreign Corrupt Practice Act. The next one, Foreign Agent Registration Act, commonly known as FARA, F-A-R-A, FARA. Well, FARA comes into play when you lobby the US government on behalf of a foreign government or a foreign entity or a foreign university. It also applies when you interact with US media, news agencies to promote a foreign position, whether it's entity or a government, a foreign position. That's why a lot of Confucius institutions around the country affiliated with different universities got into trouble because the US government considers some of them as promoting an agenda from a foreign government or a foreign university, but they did not register under FARA. And that's how this law comes into play. The next one, Foreign Investment Risk Review Modernization Act. This law is most relevant if you have a private business. A lot of the biotechnologists or biotech researchers have a business on the side, right? And then you get some investments in the business, and there are Chinese investors very interested in US biotech and other technology companies. This is when this law comes into play. Basically, when a foreign investor, whether it's government investor or a private equity or VC type of investor, invests in a US business, that investment is subject to the review by a government agency called CFIUS, Committee of Foreign Investment in the US, by CFIUS under this particular law. Next one is NIH and DoD grant rules. It's not a law, those are really agency regulations and guidances, but nevertheless, they apply very much to your grant applications. We're going to dig into some of these rules, particularly rules regarding current and pending support disclosure and other support disclosure later on during this presentation, so that when you fill out these applications, you know what to do. And of course, university ethics rules and conflicts of interest policy are very important as well. Those are not laws, but nevertheless, those are authorities that govern your, for example, tenure review or contract review. If there is a disciplinary action by your university, they will have to follow the ethics rules and conflicts of interest policy and the university grievance procedure. Usually it involves a panel review or several steps, depending on each individual university. It ranges from very stringent public unionized universities to completely private-run universities. So typically a public state university, a government-run university, has more protections. Believe it or not, they have more protections for unionized faculty members. And private universities sometimes can be very abrupt in their actions due to the lack of due process in their grievance procedure. So not every university is the same, and we can talk more about it later on. The last one is export control laws. Those of you who work in the important lab probably have heard about this before. Export control laws apply if you export controlled US technology, meaning critical sensitive technology, to a foreign country like China. But the word export doesn't necessarily mean you transfer something physically across the border. Oftentimes, tech transfer is intangible. You don't have to have anything crossing the physical border. It can just be an email, right? Or a phone call, or a file transfer from US to China of something intangible. Or you can have a foreign PhD student who might be affiliated with a Chinese government-run university. And that foreign PhD student, if he's not a US person or a green card holder, he may not have the right to access certain information or technology in your lab. So I'm sure that your university research integrity office has given some training about what kind of lab information is export controlled. And a lot of the Chinese medical universities are military medical universities. So to people with a Chinese background, we understand this, right? For example, JunHe大学, a lot of military universities, those are normal universities. A lot of civilians can attend those universities as well. But under the China initiatives, those JunHe大学 from China are oftentimes considered part of the Chinese military. And therefore, having a PhD student who is a graduate from that kind of military university or military medical school from China can make yourself more sensitive and risky in the eyes of the US government. Next slide, please. So these are the recent examples of, cases prosecuted and investigated by DOJ and by FBI under the China initiative. There are just so many cases out there. So I'm only going to highlight a few that are very high profile, right? So for example, about a month ago, January 21st, the renowned MIT professor Chen Gang 教授, he was arrested and criminally charged with 3 offenses, basically. Number 1, grant fraud. Number 2, FBR fraud. And number 3, tax return fraud. FBAR stands for Foreign Bank Accounts Reporting. So I can go into this into details later. Basically, if you are a US person and you have one or several bank accounts at a foreign financial institution, if the total amount, the aggregated amount during any part of a calendar year exceeds $10,000, you're supposed to report these foreign bank accounts to a US government agency called the FinCEN, Financial Crime Reporting Network. And failure to report might bring civil or criminal penalties. So Professor Chen has been charged with these 3 crimes. And then the Emory University professor, you probably know his name, Xiaojiang Li. These are all public information already. So Professor Xiaojiang Li, he pleaded guilty. He was not just arrested and charged. He actually pleaded guilty to criminal charges regarding, again, false tax returns. And that's the only thing he has been charged. He wasn't charged of espionage, being a spy, or stealing any IP, or stealing any trade secrets. He just didn't file tax returns on his China income related to his talents, 1,000 Talents program in China. But he was arrested and he pleaded guilty, and he was sentenced as well by a federal judge. And another very high profile case, of course, is the Harvard professor Charles Lieber case. He was arrested in his office in front of his colleagues and students, and he was criminally charged with making a materially false and fraudulent statement about his involvement in the 1,000 Talents program. His case is particularly tragic because when FBI questioned Professor Lieber before his arrest, he did not tell them that he was involved in the 1,000 Talents program. Then he turned around after the FBI interview and he told his lab associate to search on the internet whether he was actually a member of the 1,000 Talents program. And then he told the lab associate not to tell others about it. Of course, this is my opportunity of introducing an important concept and tip to all of you here. Your conversation with your students, with your colleagues, with your friends, with your confidants, none of this is protected by the law, by confidentiality or privilege. So in Professor Lieber's case, that lab associate turned around and became a witness in his case and told the authorities what he actually told that lab associate. So if you have a question, the only safe person for you to talk to is, well, there are two people in the world. You can talk to your wife, because your conversation with your wife is, or your husband, is protected by the spousal privilege. And the other person you can talk to is your attorney, because our conversation will be protected by attorney-client privilege. So even if your phone is tapped, wired, right? Even if our conversation was revealed to the authorities, your conversation to your attorney is still protected by confidentiality and attorney-client privilege. So, you know, if you feel nervous about the situation, you have questions, you want to talk to people, just remember this case, the Charles Lieber case, because the person you talk to can be a witness in your case later on. Next slides, please. So I mentioned that the Foreign Talent Program, this is a pretty typical example of the 1,000 Talent contract. This is Professor Lieber's contract. It's a public document now. So he had a contract with Wuhan 理工大学, and then he was under the senior 1,000 Talents program. There are really three types of 1,000 Talents program. The senior one, senior foreign experts. The junior one, then there is a foreign entrepreneur experts, meaning you are not having a contract or relationship with a Chinese university, but you have a private enterprise relationship, or your company may be sponsored by the Chinese government under an entrepreneur 1,000 Talents programs. These programs have different lengths in terms of how long it lasts. They have different commitments in terms of what you need to contribute to the Chinese institution or entity. They also come with different allowances. Typically, it's $1 million for a senior talents program, a million yuan, sorry, or $500,000 for a junior program or an entrepreneur program. The US government, the prosecutors, so far, I think they don't really understand that whether it's $1 million or $500,000 yuan, it's not supposed to be just paid out. It's actually prorated on a monthly basis, depending on the actual time you spent in China working on this contract commitments. So I think in all fairness to Professor Lieber, I don't think he actually worked all that time full-time in China, because he's a full-time professor at Harvard. It's physically impossible for him to be a full-time, right, according to this contract, a full-time professor at this university in Wuhan. But when the federal authorities charged him, they didn't analyze this contract in this level of detail. So they're saying they calculated how much money he got from a foreign program, and the amount was very high. And I think the amount was very high because they didn't look into the actual time he spent under the contract. But this is the risk, right? So, it's a Chinese contract. Even though it's translated into English, it's still confusing to the US government. So I think there's a fair amount of misunderstanding as to the actual commitment and compensation amount under 1,000 talents program.
I have a question. Did the federal government not look into his bank account or the real received money, that the money he received, but just look at the account as the contract itself?
I think as the case goes on and as his defense team does their job, the actual amount will eventually be unveiled. But when the federal government arrested him and charged him, the amount that they relied on was the full contract amount. And also, more important than the amount, the commitment, meaning what a person is supposed to do under this contract, can be misunderstood as well. Because anybody here who has signed a contract with a Chinese government or the university probably understands they like to make it look very grand, right? Because the Chinese university wants to promote their university in front of the government and the society in general. They want to say, we have these foreign experts, they're doing all these great work for us. They're leading a lab, they're constructing a lab for us. They are leading these, nationally critical important technology research programs. They are training all these PhD students, and all of them can be in the contract. But you probably know the reality is most of you, the majority of the talent program recipients probably only traveled to China in the summer. You spent anywhere from a week to, 10 days at that university. You couldn't possibly lead a lab or train all these PhD students. So the contract typically has language and commitments that are larger than your actual activities there. But when the US government and when your university look at this contract, they don't understand, because in the United States, a contract is a contract. Typically, the obligation written in the contracts are consistent with the obligations in real life. But in China, a contract is something on paper. What you do in reality can be very different in a contract. So in all the cases we defended, we actually made a big point about this issue. The actual compensation and the actual activities of a professor in China might be very different from what a contract says. And this is something the US government is still in the process of learning. I think they will eventually get it, but unfortunately, the learning curve is quite steep. Next slide, please. So you're looking at the arrest warrant of Professor Lieber. This is really the consequences of failure to comply with the law, right? An arrest, and he had to, he was bailed out by his wife, basically, and the family had to put together $1 million cash as the bail bond. And for scientists and any professors, this is a very large sum of cash. So it has significant consequences, not only on you as an individual, on your career, but also it has significant impact on your family as well. Next slide. So you may ask me, okay, so which federal agencies are involved in these cases? So it really depends. So the two agencies that are always involved are DOJ and FBI. Those are the criminal investigations. But then there are a lot of federal grant agency investigations that are not yet to a level of a criminal investigation. They can later on make a criminal reference of the case. However, they themselves may initiate civil investigation or academic investigation, which has the very direct consequence on you as well. Because, for example, if NIH has decided that an error and a lie was made on the past NIH grant applications, they can withdraw the funding of an existing program. They can also deny future fundings. And for anybody who works as a researcher in a university or a hospital, you know, if you lose the funding, unless you have very robust private funding or other funding from elsewhere, the loss of a funding can be very, very damaging to your career, because you're going to lose the lab, or lose the PhD students and all their resources. And the publications are going to go down. So the NIH and those federal agencies, civil investigations are important as well. Now I will spend a minute or two to talk about the magnitude of the issue. So basically about 80% of all the espionage, the economic espionage cases brought by DOJ related to China. Basically, that means 4 out of 5 spy cases in United States are about China-related activities. And then on all the trade secrets theft cases, which, by the way, trade secret theft is a criminal violation under US law. And 60% of all the trade secret cases in the country are related to China. Now let's talk about the NIH investigations. Basically, by June of 2020, NIH had contacted 87 universities and hospitals regarding their scientists. About 200 scientists, 189 scientists were named by NIH in those letters. And about 1/3 of them lost their jobs subsequently as a result of the university investigations triggered by NIH. And among these 189 cases, 93% of them had fundings coming from China. And the vast majority of the scientists who lost their jobs and who were investigated are Asian, Chinese American men, basically in their 50s. Those are highly accomplished, tenured professors who have typically worked at a university for 20 plus years, including their postdoc years. And then they're very well known. A lot of them are very well known. And 70% of those cases are not espionage or trade secret theft cases. No significant wrongdoing other than failure to disclose in a grant application their ties to a foreign country, whether it's a 1,000 Talents program or some private incomes from a Chinese company. And I mentioned these NIH, other than the civil investigations from NIH, which could cause the withdrawal or future loss of funding. NIH also has the authority to refer scientists to federal criminal investigation. And in fact, they have done that. By March 2020, they have made 27 criminal references to DOJ and FBI. And by February of last year, FBI was looking at, according to themselves, they're looking at thousands of potential cases around the country. And based on my knowledge, these numbers have been growing. The previous slides showed you that the cases that came up after February 2020 are still quite intense. Next slide. So we talked a little bit early on about the consequence. You were looking at an arrest warrant, right? So all these China Initiative investigations and cases have a chilling effect on scientific collaboration, because it's a very normal scientific activity to collaborate with Chinese universities and colleagues, co-publish papers, right? And share some results. And it's very normal to send lab species or lab samples back to China, whether because the Chinese lab may have the ability to do certain tests that the US lab you work for doesn't have that ability, or because it's there are more resources in China to fund these research. And then the China Initiative investigations certainly have a very significant chilling effect on these cross-border scientific collaboration. It has caused a lot of fear and distraction among the scientific community. I live on the East Coast. I'm close to Princeton. There are neighborhoods where a large number of people living there are Chinese American scientists, researchers in the pharmaceutical industry. During a short period of time, every door got knocked down by FBI and DOJ. They got questioned. So the fear and distraction among the Chinese American community is very real. And as a result, some of our clients told me, Catherine, I'm just going to, stay away from China. I'm not going to go to even a conference in China or work at a Chinese university during the summer. I won't even hire any Chinese students just to stay away from trouble, right? Even though I told them there's nothing illegal about hiring a Chinese PhD student or traveling to China. There's nothing illegal about, even if you are a 1,000 Talents program participant, it's not illegal. What's illegal is failure to disclose your involvement and failure to pay tax. But the activities themselves are not illegal per se. However, the chilling effect and the fear and the distraction is pretty real. And in the worst cases, it has driven some very well-trained, talented Chinese American scientists to return to China. And that's actually the opposite result of what this China Initiative policy is trying to achieve, right? The policy is to protect the US talents and technology, but the actual result is to drive talents who has the technology to go back to China. Next slide. 3 types of cases. So there are really 3 types of China Initiative cases. And then some of the cases started even before there is this the official program called the China Initiative. The first 2 types, the first type is the real bad cases, right? They're actually bad actors and espionage activities, bad cases, but that's a very small number. False positives, meaning people who are completely innocent but were wrongfully accused. A very good example is the Professor Xi Xiaoxing's case. He was completely exonerated from the espionage charge. And another case is the Professor Li Wenhe's case. So those are the false positives. But I think the vast majority of you don't need to worry about espionage cases unless you are truly a spy. But I haven't met a real spy in my life of representing all these scientists. Most of them are not spies. Most of them fall into the 3rd category of the cases. The 3rd category is non-disclosure, tax, and FBAR fraud. Basically, if you forget and didn't disclose a 1,000 Talents program or other income from China, it can get you into trouble under the False Claims Act, which is a federal offense. And it could be a tax issue as well. If you have foreign income and didn't report foreign income and didn't pay tax on it. The one thing most people are not familiar with is the FBAR, the Foreign Bank Account Reporting Program. So I'm going to spend a little bit more time to talk about FBAR. So basically FBAR, I can summarize it in one sentence. FBAR requires a US person that has a financial interest in or signature authority over foreign bank accounts, foreign financial accounts, must file an FBAR report if the aggregate value of the foreign financial accounts exceeds $10,000 at any time during a given year. So it's just one sentence. But you may have a lot of questions. What is a US person? I'm a Chinese national. I'm a Chinese citizen. I have a Chinese passport, but I'm here in the US on a green card. Does that count? The answer is yes. If you are a resident or a green card holder in the US, you are considered a US person. So the reporting obligation will apply to you. Then the next question is usually, well, what is a foreign financial account? Does the brokerage account count, right? Does a mutual fund account count? Yes. Bank accounts, brokerage accounts, and mutual funds, trust accounts, all these accounts, even if you have a trust, that accounts. And then you may ask, so what if the account doesn't produce any income? It's just money sitting there. There's very little or no interest. It's just money sitting there. Well, I may lose money, right? I did stock trading of Chinese stock in the brokerage account in China, and I lost money. There's no income. Do I still need to report? The answer is yes. Whether that foreign account loses money or earns a profit or any return, the reporting obligation has nothing to do with the income under that account.
I have a question.
Yes.
Is a real scenario here. Like you are working, say we have a Chinese citizen with a green card to stay in the US. This person is sent by her company, or say a big pharmaceutical company.
Mm-hmm.
Its local subsidiary in Beijing. And this person is designated as a signature on the bank account of that US subsidiary in China. Would he or she have to required to report that account?
Sure. I want to make a disclaimer because the purpose of the seminar is to provide as much useful information to everybody as possible. And it's not supposed to be legal advice, because in order to provide actual legal advice, I need to know a lot more facts. But generally, so if that person, he is in the US on a US green card, and he has signature authority over a bank account in China, if it's his own bank account, he has to report it, right? And the US person covers an entity as well. So if you're a US company and the US company has a foreign bank account, let's say in China or Cayman or Hong Kong, whatever, and the US company has the obligation to report that foreign account as well.
Thank you, Catherine.
Sure. So yeah, FBAR usually generates a lot of interest because people have never heard of it, or they have heard about it, but don't know how to do it. So when to do the FBAR reporting? Same as your tax time, basically before April 15th. April 15th is the filing deadline of FBAR. What form do you use? FinCEN form 114. So FINCEN, that's the Financial Crime Reporting Network that I talked about. FinCEN form, FORM form 114. That's the form you use. And then if you don't file by April 15, there is an automatic extension to October 15. You don't have to file, it's different from tax here. You don't have to file for an extension. if you don't file by April 15th, there is an automatic extension until October 15th. And how do you file? Okay, FinCEN has a BSA e-filing system, so you can follow the steps to file. And the last question I'm asking on behalf of the audience, because these are the questions I usually got from my clients. So they would ask, okay, so what do I do with all these years, right? 10 years or 15 years that I had all these bank accounts in China, because my Chinese income, the universities or companies there wired money into my Chinese bank accounts directly. I've never reported, even though it exceeded $10,000 during the year. Well, you can go back in time and amend and file delinquent FBR AR reports, similar to tax, right? So if you didn't report tax on foreign income, you can go back and amend your tax returns. In fact, the very first thing I do for a new client, let's say if a professor comes to me and say, "Hi, Catherine, I'm in trouble because I'm a 1,000 talents recipient. Well, my university may not know about this yet, but I have all these foreign incomes and I could not sleep. What do I do?" The first thing I do for him is always file tax amendment, file FBR report. Because as you can see from Professor Charles Lieber's case and Professor Chen Gang's case, these are low-hanging fruits for the authorities, right? It's hard to prove espionage. It's impossible sometimes, because if you're not a spy, how can they prove espionage? And it's even harder to prove fraud because it requires intent, right? If you made an error and you didn't try to cover it up and ask people to lie for you, it's just an honest error. It's not a crime. But if you didn't, you had foreign income and you didn't pay tax on the foreign income, it's very hard to defend a tax fraud case. So I always ask clients, please, amend your tax, pay whatever tax you have to pay at interest and penalty, and get clean on FBAR. Take advantage of the delinquent filing obligation, delinquent filing system. There are procedures and instructions you can follow on the FinCEN website to not only file for the current year, but to go back and file for previous years or amend the previous year's filing. So next slide. Now, so the focus is the non-disclosure cases. Basically, scientists are required to disclose their ties to foreign institutions when you apply for grants from a federal authority or even from a private foundation grants. And every year, your university will require you to make multiple certifications: the COI certifications regarding conflicts of interest, the OAR certifications regarding outside activity reports. Now, today's webinar hopefully is occurring at a good time because I know the annual certification season is coming up. It's usually April or early May at every university. So when this certification season comes up, you go through the university website, right? You click through yes or no, and then you report the foreign activities and the conflicts of interest. What you have in the back of your mind is to understand all the current cases, almost all the current cases are disclosure cases. So the links you click through, the software you go through, the paperwork, it's not just any paperwork. It's very important paperwork. If you make mistakes there, it can cost your job, right, and your research funding. So take the paperwork this year and in the future years very, very seriously, because the failure to take them seriously and accurately fill out these forms has resulted in terminations, resignations, suspensions, arrests, and criminal charges. Next slide. So within a month or two, you're going to hear a lot from the University Research Integrity Office, the so-called RI office. These offices, their role is to review your grant proposals to NIH, NSF. They also design annual certification process regarding conflicts of interest and outside activities. They provide training, communication, and education. But when you get into trouble, they are also the people who investigate you, interview you, search your computers, and talk to you and scare you. So my tips for you is, when your research integrity office organize trainings, attend them. I've talked to a lot of professors. They told me, well, I'm a very seasoned professor. I know how to write a research grant. These training sessions are for postdocs or for new faculty members. I've been a tenured professor, right, for 20 years. I don't need to attend those sessions. I know how to write my grants. Well, as you will hear from my subsequent slides, the grant rules, the disclosure rules have changed significantly last year. So what you knew from years ago probably is no longer current. So it's a good idea to actually attend these training sessions and hear from the Research Integrity Office directly, what a certain definition actually means under the conflict of interest policy, what the new disclosure requirements are, what forms you need to fill out, what due diligence you need to do, to make sure the information you provided is correct. So let me show you a few examples, real life examples. Next slide. So this is I'm making an example from the NYU COI form conflict of interest, right? So this is a very typical question. Do you have any academic, professional, or personal affiliations or interests with any non-US organizations, including but not limited to companies, right, governments, universities, etc.? So here, there are a few examples. They're good. They actually provided examples. 1,000 talents are particularly named. This is new because in the past, very few universities would specify 1,000 talents program or any foreign fellowship programs, but now they actually specify it. That's helpful. You also need to know there's a $0 threshold, meaning even if you don't get anything of dollar value, right, any cash from a foreign university, if there's any in-kind contribution, in-kind means materials, labs, students, other support that's not calculated in dollar amounts or cash to your bank account, but just actual support, that could count as well. So I would encourage everybody to, if you see a form like this, you click the star at the top or click the question mark. Usually something will pop up and explain the concept to you. So I would encourage you to click these marks and truly understand what's covered under every question. Next slide. This is another example. This is the University of Cincinnati form. I'm just pulling different examples. Private universities, public universities, blue state, red state, doesn't matter, right? So this is another example about outside activities, right? Do you or your immediate family member receive any income or research support from foreign governments or foreign institutions? So even if that income has nothing to do with your research projects, right? If it's just your private income or your summer job, it still counts because that's the nature of the disclosure. This is about outside activities, right? So next slide. Now, I just showed you different universities' COI forms and then also the OER outside activity forms. Let's talk about the NIH and NSF forms. there are two sections in those grant applications where researchers always fall into traps: biosketch and the support, current and pending support and other support section. In the biosketch, that's basically a resume, right? I've seen a lot of professors, they did not mention the foreign talents program or a foreign program because in their mind, and they told me, well, Catherine, this is just an honorary position. It's an honor. It's a celebratorial position. It's not a real job. And I didn't put it there because I understand biosketch to be sort of my resume section. It's not a real job. I have so many honorary titles. I don't know if I list all of them, it's going to be pages and pages, right? But it should go there because if you look at the NIH interpretation guidance about the biosketch, it includes honorary and other positions, even if it's not your full-time job, even if you don't receive compensation. And the other section that's full of traps is the current and pending support. To most researchers, so if you are a PI or a co-PI under an NIH grant application, in the past, you probably think current and pending support means other support for my research project, right? Most people think that way. So if I'm applying NIH funding for this particular research project, a topic that I'm investigating, a hypothesis, a thesis that I'm working on, I'm investigating this subject. If I have other support on the same subject, I think I should disclose it. But if I have some foreign contracts of 1,000 talents allowance, that's not tied to this particular research project. That's just in general. That's an award to me for my brilliance in general. It's not for any particular research project. Therefore, most people didn't disclose it. That's a problem because according to NIH, they said the disclosure is required, even under the old rules. Of course, there is a major dispute here because in my view, and we argue these cases all the time, in my view, the old NIH rules actually did not cover, I think, a grant or an allowance that was not tied to any particular research topic. But NIH did not think so, and they have the ability to pull your grants. So I don't think it's a good idea. Now you know it, it's not a good idea to play with the fire here. So I'll give you the comparison of the old rules and the new rules. On the next slide, you can see this is NIH and NSF has the same definition. Basically, they synchronized their disclosure requirements. You see under the old rules, current and pending and other support require information of all the current and pending support for ongoing projects and proposals, including this project. So most scientists think project means this particular research project. But if you look at the new rule on the next page, it has changed significantly. You can see now it's not a project. You don't see the word project or topic or research program anymore. It's about all the resources made available to you in support of your research efforts, not any particular PI investigation projects, any research efforts, regardless of there's any monetary value, right? $0 threshold, includes in-kind contributions. In-kind contributions are things that are not cash, right? Offices, lab space, equipment, supplies. They do tests for you. You send lab examples. They do tests for you for free. Employees, students, office space, all of these counts as in-kind contributions. So if you have any of this, you're supposed to disclose it on your grant application. Next. So here again, just to highlight the difference between the old NIH and NSF disclosure rules and the new ones after the revision. It expands from project or proposal to general research efforts, meaning your very being, your existence, the reason you are a professor is because you have these research efforts. So it covers everything you do. And it also expands to in-kind contributions, not intended for the use on this particular project. So it's extremely broad and overreaching. So now you may ask me, okay, so these rules are confusing and complicated. Can you give me some real life examples about what should be disclosed under the new rule? On the next slide, I'm going to show you a few examples. Well, 1,000 Talents program is a bad word these days, right? So you already probably know participation in the foreign talents program, whether it's thousands or Changjiang or the Fenghuang Jihua or whatever a foreign talents program would trigger this disclosure. Summer appointments to the Chinese universities counts as well. Some professor would tell me like, well, I'm on a 9-month contract. My summertime is mine. I'm a free agent in the summer. I'm supposed to be able to do whatever I want to do in the summer. That's true under your contract, but you still have to disclose it, right? And then some universities will require you to get university approval before engaging in outside activities because they have to clear the conflict of interest, whether it's a private company or a university. Other activities covered include sponsored traveling for speeches, salary, of course, a second lab, student, PhD labor, etc., and other informal collaborations. So it's very, very broad. Next page. So I hope to wrap up the presentation in about 5 minutes, then we can open the floor to questions. So on the next page, I want to share some practical advice to the audience about what to do, right? So if you're in trouble, if the university is questioning you, they took your laptop, they imaged your laptop, searched your files, what do you do, right? If FBI is asking you questions, what do you do? Or if nobody is questioning you, but you are questioning yourself, you couldn't sleep well, you hear all these news, you don't know what to do. So here are some practical tips to share. So first of all, if you are questioned, before you answer these questions, you should really hire a lawyer, but basically do an internal internet research under both English and Chinese in both Google and Baidu, because that's what the US government does. They search both in Chinese and in English, and on the Baidu engine as well. So search and understand what internet is saying about you. Because I cannot tell you how many clients of ours will say, well, if I don't tell them, if I don't give them my contract, they probably wouldn't know that I belong to this foreign talents program, right? Well, we live in the age of internet. Everything is online. Even though, China tried to wipe out all the information about 1,000 talents, once it's on the internet, it's on the internet. Oftentimes I can just do a simple search and see all these information on Baidu. Maybe it's just a lecture you gave 3 years ago, and the organizer listed out all your honorary titles in your bio before you gave the lecture, and the lecture was posted on university website. Well, boom, it's there. You're part of the 1,000 Talents program. And the US government can see it as well. And also, before you answer any questions about how many trips you made to China, how many days you spent in a Chinese university, the key is not to lie about it, right? Therefore, you should really open the passport and look at your visa stamps and travel records and have a good understanding about your travel logs. And think about all the foreign positions you have, whether you have cash income or not. And of course, do not delete emails, because deleting emails is a form of cover up and lying to prosecution, asking colleagues not to cover up for you. Those are all bad ideas. But you should definitely exercise your rights to legal counsel and understand that when you are questioned, there will be a lawyer in the room, but that's not your lawyer. That's university's lawyer or government lawyer. That person is against you. So you need to have your own attorney. And you should always exercise your rights to a grievance hearing if they threaten to terminate you, because under the university policy and the rules, most of them have proceedings and due process regarding how to terminate a professor, especially if you are a tenured professor. So given the time constraint here, I'm going to jump to the last page, do's and don'ts. As a quick recap of some of the advice I provided. So basically the things not to do, those are very important. If you have your cell phone with you, take a picture of this slide. This wraps up a lot of the important things I want to say. But the most important thing, if you can, if you can remember one thing from the webinar tonight, you should remember the tax and FBAR, because it's very hard to defend somebody, as I said, on these violations. Other things, if you are innocent and you didn't purposefully commit a fraud, keep it that way, meaning not to cover up and not to delete emails and not to talk to other people about it. Basically, don't change that status. The status quo is you're innocent, right? An error can be made about a disclosure. That doesn't mean it's a crime. It can be an honest error. But once you start to delete emails and talk to other people and ask people to cover up for you, it becomes fraud. So as my white-collar criminal defense colleagues on my team will always say to people in the situation, oftentimes it's not the crime, it's the cover up. So you are innocent and try to do everything to preserve that status. So that wraps up my presentation for the evening. We can, perhaps Sean, we can end the slide sharing and just have Adam back on the camera so we can have a conversation with the audience. Adam, I see a lot of questions in the chat box.
Thank you very much, Catherine. It's very insightful. Very insightful. And I'm going to, there are already several questions popping in, and I'm going to pick up those, those questions. The first question, Catherine, is many of the science community members are working in the life science industry. Some of them are building or running their own companies. You mentioned about the biology or sample issue, okay? Is there any special attention we need to pay to avoid potential trouble?
Right. So a few things. There's the export control regulations. So you need to understand whether your biology examples are controlled substance for export control purposes. And if they're under export control regulations, then exporting to a certain countries, not necessarily every country, right? If you send it to a lab in Taiwan, that might be very different from sending the sample to mainland China. So the destination is important as well. So before you send lab examples, you need to understand whether those examples are export controlled substance. That's one. The other issue is, so if you have a lot of biotech professors and researchers have a company on the side, or they consult for a company, or they are on the board of a company, you have to disclose that in both of your COI form and the outside activity reports. Because yeah, those are different from the talents program, not related to Chinese government, but those are outside activities. Those might pose a conflict of interest with your university. So you are not in a position to say whether there's a conflict or not. So the only thing for you to do is to disclose it, and for the university to make an informed decision whether that kind of outside activity actually poses a conflict of interest with the university. If it doesn't, more likely than not, they will allow you to continue your activity. Then you're fine, right? You have the peace of mind. You disclosed it, they approved it, you have your peace of mind. But not to disclose it is, I don't think it's wise under the current situation.
Great, thank you. And on the point of, our conflict of interest or similar activities related to a foreign country, do we report to the activities a year ahead, like or beyond a year? I guess the question is.
That's a great question. So if you read the COI, the conflict of interest form, every university specifies the time frame that applies to the disclosure. What's typical? I showed you the NYU and the University of Cincinnati examples. Those are very typical and representative of other universities' disclosure requirements. It usually says within the last 12 months or within the calendar year of 2020, or, from January 1st this year until blah, blah, it will specify the time frame. I know you're scientists, you're not lawyers, you're not trained to read these definitions and fine prints, but you have to read the question, and the question typically will tell you what the time frame they're looking at. So let's say if you have some outside activities from 2 years ago, you probably, again, you have to look at the form, but more likely than not, it's not covered by this year, because this year you're supposed to certify to last year and this year's the current activities. So take a look at the time frame covered by the report.
Thank you, Catherine. And on the FBAR, we have a question. This person asked, the report I made last year was FINCEN. And this
FinCEN.
Foreign income report. This is the FBAR report?
Yeah, so if it's a FinCEN form 114, that's the Financial Crime Network, that's the FBAR report. That's not on your tax form. So FBAR is separate from the tax form. So people said, well, it doesn't have an entry on the tax form to report it. Well, it's not on the tax form. It's a separate form. It's on the FinCEN form.
Yeah, thank you, Catherine. And then we have a question here. If the income went to an account that is not under my name or my immediate family's name, do I still need to disclose?
Well, I get this question every time I talk about the FBAR issue. It's a very Chinese question in a way, right? Because we have great family relationship. We trust our mothers and parents. Most Americans will be horrified if they give the control of their bank accounts to their mom. But, great Chinese tradition, the FinCEN actually covers this, because if you have signature authority on the account, it counts as your account. So if it's under your name, or if you have signature authority. But if you just completely give it to your mom or your brother, it's under their name, they have signature, technically they can take the money away. It's not your money anymore, it's their money, right? Then it doesn't trigger the FinCEN requirement.
Yeah, thank you. And someone was curious, she thought, or he thought, like if the FBAR reporting threshold is $50,000 years ago
No, the current threshold is 10,000 and it's aggregated. So if you have 5,000 in one bank account and 5,000 in a brokerage account, it adds up to 10,000.
Good. And then we have a situation where FBI agent shows up at your door to invite somebody for lunch. How to verify their identity? Badge, no picture, no name card?
Wow, there's no free lunch, especially FBI, but they always pose as very friendly and just a casual conversation. I spent a lot of time yesterday talking to a friend in San Francisco. He had the same situation. Two FBI agents wanted to talk to him. They showed up. They're very friendly. And according to them, he was not the target of the investigation. He's just a witness. So I would say, ask for their identification for sure. Ask for their business card, because once you see their business card, you can see which division are they from. Are they from the intelligence division, meaning they think you're a spy, right? Or are they from the fraud investigation division, which means they think you might have committed fraud? So look at what division they're from and then listen to their questions. I would be, cooperative and listen to their questions, but you don't have to answer the questions, right? Because if you answer it, even if you don't have bad intention, you might make a mistake that might be used against you. For example, they can ask you, do you have Chinese income in the last 5 years? How can you remember all of it? Remember, I told you, you have to look at your passport, look at all your visa stamps, look at your Outlook calendar, and think about, oh gosh, all the seminars I gave, all these trips, the conferences. Oh, did this university give me 5,000 yuan just to cover my trip? Oh, should be disclosed. It's a sponsored trip. But in that one sitting or lunch, the FBI is with you. How can you remember all of this? So you may be very well intentioned, but you might accidentally make a mistake. And they would think you're lying to them if later on they find out the information you provided on the set was not accurate. So the best response, it sounds so self-serving, Adam, but the best response is get their name and business card, listen to their question and say, I need to talk to my attorney. I have nothing to hide, but I don't understand this procedure. This is so new to me. I invoke my rights to have an attorney before answering your question. There's nothing wrong with that.
That's great advice. Thank you, Catherine.
Yeah, because a lot of researchers think, oh, once I say I need to have an attorney in the room, FBI thinks I have something to hide. So I better not to have an attorney. That's just not the right way to think about it in this country.
And we need to be educated about that, I guess, as Chinese. And another question, can we record the talk with FBI?
Oh, well, so every state has different laws about recording. In some states, it's a felony, meaning it's a minor crime to record a conversation without the other person's consent. In other states, it's legal to record without the other party's consent. So how do you know, right? In every state, it's different. If you record it in a state that requires the other person's consent, you've been committing a crime against the FBI. So it's probably not a good idea to record a conversation.
Thank you, Catherine. Yeah, I guess, this will be the last question, and it's a great question to conclude this conversation. But before we do that, Catherine, you want to remind us that, this is not a legal advice to any of us, right? So if you have questions, just, use the contact we share with you to send email, call your office, something like that, right?
Right.
Okay, thank you.
So I just want to clarify that the reason Adam and I are spending the time with everybody tonight, evening time, and to educate this audience is because as attorneys, neither Adam nor I are allowed to provide any legal advice to any person who is not a client of our law firm, right? Adam, your firm has the same policy, right?
Absolutely, this is the ethical rules.
Policy. So if you just call me tomorrow and ask me questions, I won't be able to answer your questions unless you are my client. That's why we're spending the time, it's a 公益讲座, right? Spending our time to give this pro bono service to the community and to educate everybody. Hopefully everyone walk away with some helpful information. I'm sure a lot of you will be on the FinCEN website tonight, looking into the FinCEN report, the FBAR report. But if you have any specific questions, definitely you can contact me or Adam. We will help you as much as we can under the boundary of the law firm policies. But if you want to work with us, we certainly welcome the opportunity to provide the legal service to you.
Catherine, thank you very much for speaking for our shared passion to this community, because we want to be helpful to our scientist friends, who may not, are be so familiar with the U.S. legal procedure and the pitfalls we may fall into. That's our pro bono or mission to so to say it. So this is the anticipated question. Will the slides be shared, Catherine?
Yes, I will be happy to share the slides. These are copyrighted slides, but I'll be happy to share them for your own use. So please do not copy them and send it to hundreds of other people. But I will give CABS, our great sponsor and organizer of the event, the authority to post our slides on their website. So if you're a member of CABS, hopefully you can go to their website and look at the slides.
Thank you very much, Catherine. You are very generous. And thank you, Dorsey, Whitney as well for your generosity. And the last question here, as we close, is, Catherine, what do you think? Will the Biden administration continue the China initiative?
Oh, this is a great question. It's truly a very, very insightful question. If you look at all the anti-China regulations that got passed in the last 24 months, every anti-China regulation, whether it's the Hong Kong Human Rights Act or the Uyghur Forced Labor Prevention Act, or all these sanction-related regulations, or the CFIUS regulation and export control laws I talked about, every single one of them had bipartisan support. If anything in this country nowadays that still has bipartisan support, it's anti-China. And then all these laws were passed by Congress unanimously, and they were passed by the Senate close to unanimous vote. Usually there was only 1 or 2 vote against it. Everybody else, whether Democrats or Republicans, were for those regulations. So the Biden administration, I think the tactics might be different, the tone, the rhetoric might be different. It might be softer, a more toned down version of it. However, I don't think it's going away anytime soon on a nationwide basis. Because if you look at some of the recent cases, they're very recent, right? The latest case was February 3rd, and there are still new cases even after Biden became the president. And the reason for that is the law is the law, right? All the regulations I just showed you, False Claims Act, the export control, NIH rules, which are brand new. They just passed it last year, 2020. They're not going to go back right after they passed the new NIH rules and all the university policies and procedures. So I have to say, China initiative has been, at this point, institutionalized at every university and every hospital around the country. Now, the bright spots is because of the change of presidency, US attorneys in different locations may change. The latest example is the Boston area, the Massachusetts Attorney General, Andrew Lelling. He stepped it down. Andrew Lelling is the most prolific prosecutor on China initiative cases. He was the one who arrested Professor Lieber. He was the one who arrested Professor Chen Gang, not personally, but he signed those, he authorized those warrants, and he was put in place specifically for China initiative. So we will see changes of people's names, changes of these US attorneys in different districts. that means, the prosecution efforts might fade away a little bit. However, I am reluctant to say this because I don't want anybody to walk away from tonight's seminar thinking, oh, because we have a new president, because people like Andrew Lelling and all these hawks are going to be replaced. Therefore, I can just, do whatever I want to do and not to disclose it. That kind of logic may be harmful because you're basically relying on others, right? Relying on politics, relying on a new president, or relying on a different US attorney in your district to determine the future of your fate and your career. While you yourself have a lot to do to control your own fate, right? You can get clean on tax, file the FBAR, and make a good disclosure on the COI form. Then you don't care who's the president, and you don't care who's your US attorney in your district. You control your fate by yourself, by being a compliant and law-abiding citizen. Then you don't lose sleep, no matter who is in power, right? So that's something I want you to take away. I don't want people to think all of this is racial discrimination, all of this is just politics, all of this may change because we have a different president. It might be true, but I don't think it's helpful for the scientists out there. What's most helpful is to protect yourself and do what's in your power to help yourself and help your family.
Thank you so much, Catherine. It's very well said. And thank you so much for your passion, for your compassionate, undertaking to this audience. And I also want to thank again our Dorsey, Whitney, the wonderful team to support this, and of course of our leadership of CABS, and last but not least, all the participating members of this seminar. Thank you again.
Yeah, one last thing. May I ask every Dorsey member to turn on your camera and just quickly say goodbye to the crew, to our audience. Maybe they're already in their pajamas.
It's too late for them.
Our technical support. They are the IT people who made this seminar possible, working overtime. And those are our American friends, right? You can see their names. They're super sympathetic to this community and they want to help us. So I want to thank them for their efforts tonight as well.
Thank you, Catherine. Thank you, Chang. Thank you, everyone at Dorsey. And thank you. You guys have a good night. Oh, by the way, this is Chinatown, the Red Lantern Day, right? You must be receiving a lot of congratulations and the
end of the new year.
or greetings. If you celebrate that day, happy holidays.
Happy holidays.
Happy holidays. Thank you so much, Catherine. Thank you, Adam. Bye-bye.
Thank you. Bye-bye.
Bye-bye.